let me try to figure out how this would work in practice, Professor Bray. I was Attorney General of Rhode Island. As Attorney General of Rhode Island, I had various responsibilities to protect the health, safety, and welfare of the people of Rhode Island. Rhode Island is a downwind state from a great deal of air pollution that takes place in other states, to the point where even if we eliminated air pollution in our state, we would still have real air pollution problems because it comes in from other states. So it would not be the least bit improbable for an Attorney General of Rhode Island, which I did, to sue EPA, for instance. So let's hypothesize that you have an EPA that is currently the stooge of fossil fuel industries, and that they put out a rule that is driven by fossil fuel stoogery rather than the facts. And as a result of that rule, there are more emissions and therefore more harm to Rhode Island. As the Attorney General of Rhode Island, I sue EPA over its regulation. I argue and allege that it is arbitrary and capricious. And for a whole variety of reasons, the district court, either in Rhode Island or in Washington, the district court says, yep, Attorney General Whitehouse, you are right. This rule was phony, and it's arbitrary and capricious, and they didn't meet the requirements of administrative law, and therefore you win. What if I won?
Mm-hmm. So I want to answer this with two kinds of lines of response. So one is, for dealing with procedural violations by agencies, mandamus is an important remedy, and it's one we haven't talked about, and it focuses—
Don't go steering off. Stay with my fact pattern.
Right. It focuses on the duty.
Mandamus is not involved.
But I think here that—
Fundamentally, you had a corrupted decision that didn't stand on the facts, let's just say. Not necessarily a procedural violation, but the rule can't stand. Now, do I have to go to all of the upwind states?
No, you do not, because the court's injunction can protect you. So what the court could do is say that the rule cannot be applied in the upwind states because that affects you. So the key move here is you shouldn't think about the state plaintiff as getting a win for a geographic area, but rather it is whatever it is that injures the state plaintiff. So you actually can get an injunction that makes you whole, and it doesn't have to stop at the state border. But the point is that—
So you are comfortable with an injunction based on the arbitrary and capricious nature of the regulation that would require adherence to the previous, better, stronger, existing regulation in 15 or 20 upwind states.
Whatever it takes to protect you. Whatever it takes to protect Rhode Island, but you couldn't go to court and get an injunction protecting California.
Do I then have to go and litigate that state by state? What if one state says, well, I'm not really upwind, or I think it's de minimis because there's so many of us here. Why do I have to bear that burden of fighting through defining what the upwind quality is when I'm the one who has been hurt by a phony regulation, which has been found by now a court of competent jurisdiction to have been phony? Why do I need to go on this escapade?
So you wouldn't need to go on an escapade. You wouldn't have to go to each of the other courts. The court you go to could give you an injunction that protects you and makes you whole. And in fact,
so I'm still in, let's say, district court in Rhode Island,
right?
Hypothetically, do I then ask the court for a determination as to which—
Yes, in fact,
which companies need to comply with the previous, and then you have a separate hearing in which you bring in, you have to go through a whole separate process in which each power plant and each emitter has a chance to make the case that they're either de minimis or for whatever reason that I've got the wind patterns wrong, that they're not truly upwind.
Well,
why do I have to go through all that when I started with a bogus regulation that's been struck down to begin with?
Well, the court would decide that on the basis of the evidence you put forward and the evidence that the EPA puts forward.
But you'll concede that that's a whole new area of factual litigation that I now have to take on. I now not only have to take on the fact that they wrote a phony, corrupt regulation and that I won and done, thank you. I now have to go into a whole second arena of litigation to try to determine which smokestack sent which particle.
So I don't.
Why do I need to do that? Why is that a sensible outcome?
I don't think it has to be quite that granular, but the reason for this goes to the power of an injunction. An injunction is enforced by contempt. And so the federal rules require that every injunction clearly specify exactly what its conditions are, exactly what its scope is.
And this couldn't be clearer. This rule is corrupt. It fails the test of arbitrary and capricious. It is invalid. It is struck down. Period.
So if it is,
why isn't that good enough?
If it is that clear, then other states and other plaintiffs should either band with you to bring a class action, or they will all win their cases in their courts of appeals, and it will all be decided. And so if it actually is a patently illegal rule, then it will lose everywhere.
Time is up, but I think we're adding an awful lot of peculiar litigative complexity in order to achieve an academic result that isn't all that real from a point of view of somebody whose job is trying to protect public health, safety, and welfare. Thanks.